Hello everyone, and welcome to our lecture recording for Chapter 6. This is in relation to the applications of negligence to business, and as usual we will go through the chapter using the chapter objectives that you can find on page 158. The first objective asks us to identify and explain the application of the tort of negligence to occupier's liability. The discussion starts on page 159, and if you recall, we talked about occupier's liability previously in chapter 5 on page 127. So if you go back to 127, you will find that occupier's liability is one of the settled cases. So there we said that in the majority of cases that come before the courts, whether the defendant owes the plaintiff a duty of care can be determined from precedents. And examples of these precedents is this idea of occupiers owe a duty to persons who come onto their property. Now, in order for us to establish occupier's liability, we will have to go through the following analytical structure, and this is given to us pretty much the same way that we do negligence. So occupier's liability is just one of the precedents where we don't have to argue the existence of a duty of care, because that has been already established through precedent. The plaintiff will need to establish first that the defendant has occupation or control of the land or structure. So think of something like a supermarket, and that this defendant was negligent, so there was a duty of care owed. Based on our definition that this is a precedent, this is really not an issue, because you can establish that simply by referring to the precedents. Secondly, you have to argue that there was a breach of the duty by the defendant, and finally that there were damages sustained by you as the plaintiff, and you would like to have compensation for those damages. Now, the key issue in relation to occupier's liability is definitional. So you have to establish who is an occupier. So that's what you find on page 160. So in order to succeed in this case of action, the plaintiff must establish that the defendant has occupation or control, okay, of the land or structure, which is a question of fact. Okay. Most importantly, ownership is not enough. At the bottom of the page, it says control and physical presence on the defendant's part are primary considerations, although it is not necessary for a person to have entire control over the premises. Then you move on and you'll find some more explanation of what a premises is. So this covers both fixed and movable structures. So premises include a wide range of fixed and movable structures, such as plant and machinery, as well as movable such as ships, railway carriages, and even ladders. Okay, so the idea of an occupier and the premises that they occupy is rather wide, but as we said, over time the rules that once applied to occupiers have now been incorporated into the general duty of care of the law of negligence. Okay, and there are a number of factors, okay, that the court looks at in order for them to decide whether this occupier has discharged their duty of care in relation to the plaintiff. And these are given to you on page 163 at the top of the page. So deciding whether the occupier has discharged their duty of care, a court must consider the gravity and likelihood of the probable injury, the circumstances of the injury, the entry onto the premises, the nature of the premises, and the knowledge which the occupier of premises has or ought to have of the likelihood of persons or property being on the premises, the age of the person entering the premises, the ability of the person entering the premises to appreciate the danger, and the burden on the occupier of eliminating the danger or protecting the person entering the premises from the danger as compared to the risk of the danger to the person. Now if you go back and look at what we talked about in relation to breach of duty in chapter 5, you'll find that there are similarities between these factors and the factors we looked at in that chapter. So if you go back and look at page, for example, 138, you'll find that there is similarities between these factors that we look at in relation to occupier's liability, and this is one of the reasons why eventually this cause of action was incorporated or came eventually under the larger umbrella of this cause of action we call negligence. Now you'll find on page 163 that it says causation is an important issue. So when we talk about it in that sense, we mean that it's an important issue in relation to your analysis. If you have, for example, a problem-solving question that covers a situation that is defined as an occupier liability scenario. So the onus is on the plaintiff to establish that the defendant has not taken reasonable care, and then you have an example of these problems that we call the spillage cases, and it talks about one of the cases there with Woolworths, where they talked about where a substance has been spilled in premises through which a large number of people pass, such as a supermarket, and says the duty of the occupier to have a reasonable system of cleaning and inspection in place. Okay. So to sum up basically is that in general an occupier of premises owes a duty to care or to take reasonable care to ensure that anyone on the premises does not suffer injury or damage because of the state of the premises or things done or omitted to be done about the state of the premises. So the most important questions to consider, so this is on page 162. The first one is, would a reasonable person in the circumstances in the defense's position have foreseen that the conduct involved a real risk of injury to the plaintiff? If the risk is real, and it doesn't matter if it is remote or unlikely to happen, then the second question is, what would a reasonable person do in response to the risk? What would a reasonable person do in response to the risk? On page 163 they talk as well about the subset, if you like, of occupiers who are the recreational providers. Okay, so these are people that provide recreational services, and they of course are considered occupiers in that sense based on our definition of what an occupier is. The question is, what's their liability in relation to the people who come to use these recreational services? Okay, so generally they are not liable for the harm suffered by a plaintiff if the risk is obvious or it is inherent. Okay, so you'll find that there's a discussion there on page 163 in relation to an obvious risk. So this is a risk that would have been obvious to a reasonable person in the position of the plaintiff and combine subjective and objective elements. You will find more on this idea of obvious risk on page 150. So if you go back and look at that there as well and link it to what we are talking about here in relation to recreational providers. But there's also the recreational activity definition below that, which says recreational activity includes any sport, any pursuit or activity engaged in for enjoyment, relaxation or leisure, or any pursuit or activity engaged in at a place. And it gives you an example of a beach or a park or other public open spaces. Now the same thing applies to a dangerous recreational activity. You can link this idea of a recreational activity to what you read on page 134. So if you go back to 134, there's also a discussion about recreational activities and the duty of care. But we also want to talk a little bit about this idea of a dangerous recreational activity. And it says a dangerous recreational activity is an activity engaged in for enjoyment, relaxation or leisure that involves a significant risk of physical harm to a person and can include activities such as spotlighting or shooting kangaroos, diving from a bridge, riding BMX bikes, or recreational flying, and so on. You can link that as well to the Rigby case on page 160 in relation to the BMX activities. Now the most important thing here is that if the plaintiff has been given a risk warning about the activity being undertaken, if they have been given a risk warning, then we know that the recreational provider or the occupiers are not considered liable for harm. So it's not necessary basically that the defendant established that the person received or understood the warning or was capable of receiving or understanding it. Okay. So the warning clause relied on by the defendants in a case like Irwin or the Belknap Proprietary Limited says that the warning clause relied on by the defendants failed because it did not warn Irwin about any risk or risks involved in the exercises that she undertook. So it was not a risk warning in terms of the act. So the idea there is that it didn't actually warn of the risks, but you don't need to ascertain that the person that received the warning understood if you have given them the if you have indicated the risks involved, and if they haven't understood that, then it's not necessary to prove that they did understand or not. Furthermore, you'll find below that on page 164 it says a defendant will not be able to rely on a risk warning unless it is given by or on behalf of the defendant or on behalf of the occupier where the relational activity is being held. If it is established on the balance of probabilities that, and you have to go through the 3 points there, the harm resulting from the breach of an act, the established procedures or practices for personal safety, the warning was contradicted by any other representations, and the plaintiff was required to engage in the recreational activity by the defendant. Alright. Let's then move on to our second objective, which asks us to identify the protection provided to consumers under tort of negligence. This starts on page 165, and you'll find that consumer protection legislation allows incorporation of an exclusion clause, a waiver, or disclaimer. Okay. So some jurisdictions have already allowed the recreational providers to avoid the problem of liability by allowing them to incorporate an exclusion clause. Now, if you pay and you enter the recreational facility or the premises because you have entered into contract, so you've paid an amount of money to enter, this brings in not just the area of tort law or negligence, but it also brings in the area of contract law, which we will be covering in the following weeks. So if a person can establish entry by contractual right, then the nature of the duty owed will turn on the express or implied terms of the contract of entry. So now, because there's a contract, the duty that we talked about as a precedent in relation to occupier's liability now is modified based on this contract between the person entering into the premises and the person providing the services, or the recreational provider. Now, where there's no express term that excludes the occupier's liability, there is an implied term in the contract, so we imply it into the contract, which establishes that the premises are as safe for entry as a reasonable person can make them. Okay, so a person who has paid the price of entry can bring an action. That means you can sue someone either in tort or in contract. Either in tort or in contract. A last point I want to talk about is on page 166 in relation to third-party liability. Okay, so generally speaking, occupiers have no duty to take reasonable care to prevent physical injury to a third party. Okay. This, however, is different if there is a special relationship. Okay. So as it says there, if there's a special relationship, so for example between a school and a student, then the school might still be liable for this third party injury. So injury caused to the students by someone else other than the school. However, the duty generally does not extend to prevent injury being done to another through the criminal conduct of a third party, even in cases where the harm is foreseeable. Alright. You'll find that there's further discussion of public liability, public authorities under there on page 166, and again it talks about general principles to be employed in determining whether a public authority owes or has breached a duty of care. These apply to any claim for damages resulting from negligence, regardless of whether the claim is brought in tort, in contract, or under statute or otherwise. And what we mean by public authority, we mean things like local council, the Crown of course, local council, or any public authority established by or under an act for a public purpose. Okay. So a court must also take into account three things: financial and other resources that are reasonably available to the authority, the broad range of an authority's activities, and evidence of compliance with general procedures and any applicable standards. Then we will talk a little bit about something called non-delegable duties and strict liability. Now you can link this part to other parts of this textbook. For example, page 944 on the duty on employers. So in addition to the duty to take reasonable care, there is in a limited number of situations a more onerous duty. So this is the duty to ensure that all reasonable care is taken. This non-delegable duty is not an absolute duty to prevent harm. Rather, it's a duty to take reasonable care, but one that cannot be delegated. And the most important example of that is the employer-employee and landlord-tenant and hospital-patient and teacher-pupil relations. There was something called the rule in Rollins and Fletcher, which we talk about a little bit just beneath that in the next paragraph. It says, where a person who had control of premises brought a dangerous substance onto the premises or carried on a dangerous activity or allowed another to do one of those activities and it escaped and caused damage to another's property, they would have been liable under the rule in Rollins and Fletcher, which is a case of strict liability. Okay, but now of course this was also incorporated under the big umbrella of this cause of action we now call negligence, under the cause of action of negligence. So the key point to remember is that in each case where a non-delegable duty of care exists, there's a higher standard of care required by the person owing it, with respect not only to what they do, but also to ensure that where tasks are delegated, they are carried out with reasonable care and skill. Alright, so we can then move on to talk about product liability under still this second learning objective of consumer protection under negligence, and this starts on page 170, and it's really straightforward. It says again that manufacturers are liable under both common law and statute. So this is a continuation of our discussions on Donoghue and Stevenson, that there's this product liability. However, there's a proviso there that, again, just like the ginger bottle in Donoghue and Stevenson that was opaque, here product liability, in order for it to be made against the manufacturer, the defect must be hidden and unknown to the consumer. Okay. Same thing, there's a discussion there again in relation to things like defective structures, where the premises suffer a defect, and it could be reasonably foreseen that a person could suffer injury as a result, the builder or the architect or the engineer may be liable. So the discussion starts on page 171. Alright, we have discussed, if only briefly, this idea of non-delegable duty. So this is again on page 167, and again it says that there's a higher standard of care, especially in relations, for example, like an employer and employee. Alright, so let's then move to our third objective, which asks us to discuss and explain negligent misstatement and the prerequisites for recovery of damages. So our starting point is going to be on page 172, and in order for us to make this cause of action, which is again something related to negligence, you will have to go through the analytical structure that's given to you on page 177. So as you do with negligence generally, you have to establish a duty of care and that the duty has been breached, and because of that breach, so the causation factor, there were damages, and there was damage, and you will have to be compensated for that damage. Now, as it shows in the brief box on page 177, regard must be given to all the circumstances of the case. It says, while reasonable foreseeability is important, just like we discussed it under negligence in chapter 5, the relationship between the parties, combined with reasonable reliance by the recipient on the misrepresentation and an assumption of responsibility by the speaker, must be shown. And then there are other factors that the court has taken into account, things like the environment, so professional or social or request for information, and the seriousness of the inquiry in the context of the environment. So if you make an inquiry, for example, to a friend, is very different from making that inquiry to probably the same person. But if you actually go and talk to them at their place of work, say in a council, in a local council. Other factors, whether there is a voluntary assumption of responsibility or if it has been excluded, and whether the maker of the statement should know that the statement is to be used for a serious purpose, or whether there is a third-party reliance. Now, once you have established that there's a duty of care, you need to go on and establish that that duty has been breached. So you must establish that the defendant made a representation or statement. So this is the difference when we talk about negligent misstatement. The act here is that this representation or statement were made, and that the defendant knew or ought to have known it was being requested for a serious purpose, and that the representation or statement by the defendant would be acted upon. So actual reliance. Finally, you have also to establish that if the statement was inaccurate, that you could suffer loss. Finally, you talk about the damage. So you must establish that there is a connection between the defendant's omission and the damage that the plaintiff suffered. So this is what we called previously causation, or the causative element. Now, in relation to professionals, and the definition again is given on page 177, it says a professional is a person practicing a profession which includes doctors, okay, and may include other professions such as dentists, architects, and solicitors. Okay. Most importantly here is that the standard to be applied by the court in determining whether such a person has acted with due care is determined by first reference to what could be reasonably expected of a person professing that skill and the relevant circumstances as at the date of the alleged negligence, and not at a later date. Okay. The professional can avoid liability, okay, if it's established that they acted in a manner that was widely accepted by peer professional opinion as competent professional practice. So you can look at that discussion as well on page 178. Let's then move on to our fourth objective about the concept of vicarious liability, breach of statutory liability, and impact of other civil liability reforms. The discussion starts on page 178, and we'll start with vicarious liability. The idea of vicarious means that you are going to be held responsible for the actions of someone else, even though you didn't intend for those actions to be taken by that someone else. So this is why it's a form of strict liability. Okay. Mostly this will come in the context of this employer-employee relationship. So if the employee commits a tort, for example, or are negligent, to be specific for our purposes, then the employer is going to be found liable for the actions of the employee. So the employer in this sense is ensuring the actions of the employee. Okay. This, in order for this to be made, so in order for it to succeed in making an argument on vicarious liability, you have to show that the actions of the employee, okay, were part of their employment. So the employee was acting in the course of their employment. Okay. So if they are an independent contractor, you cannot go and argue that the employer would be vicariously liable for them. But if you can show that they are really agents for the employer, agents for the employer, then you could still probably succeed on an argument of vicarious liability. Okay, but then of course the employer can turn around and sue the employee for breach of a term of their contract of employment if the employer is found vicariously liable. So the idea here is that instead of you going after the employee, which most likely than not will not be able actually to compensate you for any damages you've suffered in terms of monetary compensation, so you would go after the deeper pockets of their employer. But in order for you to do that, you need to make sure that the employee who committed whatever negligent act and which resulted in damage to yourself, then you need to make sure that that person, the employee, was acting in the course of their employment. All right. Now there's also something I want to talk about, which is called breach of statutory duty. You'll find that on page 181. This is separate and distinct from negligence. Okay. So a breach of statutory duty can arise without negligence. Okay. Because a strict statutory standard of care may be imposed. A strict statutory standard of care. So if you go and analyze it under negligence, you'll find that the standard of care is met, but by statute we lowered that or raised that standard of care, so you would be in breach of it even though you are not actually negligent. So on page 181 it continues saying, however, private liability may arise simultaneously where the breach of statutory duty constitutes evidence of negligence. Okay, so it could be used as evidence of negligence. So most actions for breach of statutory duty involve motor traffic and workplace injuries. Okay, and the standard of care is going to be determined by the words of the statute, and the breach must be the cause of the plaintiff's injuries, which were of the kind that the statute sought to prevent. Okay. There's also discussion of other forms of civil liability, other reforms of civil liability. The first one is in relation to volunteers and community organizations. There's of course also some reform in relation to motor vehicles. So in the event of personal injury arising from a motor vehicle accident, some states have retained common law actions, what's known as fault-based schemes, and others replace them with no-fault schemes. And you can see that on page 182 there is a table showing the jurisdictions in Australia, and each one of them a description of the scheme that applies in that jurisdiction in relation to motor vehicle accidents. But there was also other reforms in relation to volunteers and community organizations. So basically, in a nutshell, the liability attaches to the community organization for which the volunteer works, not to the volunteer themselves. Okay, and you have the definitions there of community work and of volunteer and of community organization. There's also discussion of Good Samaritans, and that's on page 183. And again, protection for Good Samaritans from liability is now provided for an act done or an omission made honestly, so without recklessness, in assisting or giving advice about the assistance to be given to a person who is injured or at risk of being injured or in need of emergency medical assistance. Now note that protection from civil liability will not apply except in Victoria if the Good Samaritan was intoxicated, okay, while giving the assistance or advice or caused the injury or risk of injury in the first place. So while we are going to protect these Good Samaritans, we will protect them only in most jurisdictions if they are not intoxicated. So if they have done something to help someone but that resulted in damage because they have done something or omitted to do something, and they were not intoxicated, then they would not be found liable. They would not be found liable. Alright, let's then move on to our fifth objective for today, which is discuss the requirements to prove criminal negligence and obtain a conviction of the defendant. And our discussion starts on page 183 with criminal negligence, and simply says if the injury is to the person and the actions of the offender are sufficiently reckless, this is the key point, sufficiently reckless, their conduct could amount to what's known as gross or criminal negligence. Okay. So examples are things like causing grievous bodily harm, okay, or if the injured party dies, it could also be manslaughter. Okay, and the most important thing, because it is criminal negligence, it's the Crown who's going to be prosecuting, so it's the onus on the Crown to prove the case. As we do in criminal law, it has to be to the standard of proof beyond reasonable doubt. However, before a conviction can be made or obtained, the Crown has to show beyond reasonable doubt that the defendant did the following. This is on page 184. First, that the defendant or the accused owed the prescribed duty of care, disregarded what was such obvious risk of injury to the complainant, caused death or injury to a member of the community, and had acted in such a way as to deserve punishment. The proviso at the bottom of the page says at least some serious harm must be reasonably foreseeable by the accused. In other words, the behavior of the accused must be such that it can be said that they failed to use reasonable care and take reasonable precautions to avoid danger to the complainant's life, safety, or health. So there must be a high degree of culpability to establish a case in criminal negligence. And you are given these two cases on page 184 and 185. You have the Crown and BBD, and then the Crown and Clark, and you can see from the names of these cases that they are criminal law cases. So when we talk about criminal negligence, you've jumped now back from negligence to criminal law, and we also talked briefly about some also overlap between tort law and contract law. And it is this contract law part that we will expand on in our next lecture. So that will start us on part 3 of the textbook, the law of contracts, and it is the introduction to contracts that we will see in chapter 7 for the next lecture recording. And until then, I hope that you enjoy your weekend and have a very successful time reading through the textbook and attempting your assessments. Thank you for listening, and bye for now.